Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Fatin Farhana binti Ahmad Yazid, number matric 272211. In this video, we are going to talk over question of assignment 2, which is part 1. Here, we are going to discuss 3 different situations. First is the number of shareholder required for a private company. Second situation is conflict of interest among directors, shareholders, and company itself. And lastly, conflict arises under pre-incorporation contracts.
Hi, my name is Nina Hani binti Ramzi, number matric 272168. Let's start with the first issue, whether Tuba Energy Sdn Berhad can have 57 shareholders. So for this situation, we are going to refer to the law under section 42(1) Company Act 2016. Under this law, it is stated that the membership of a private company like Tuba Energy Sdn Berhad shall not exceed 50 membership, as it is the maximum membership required. The suggestion to Tuba Energy Sdn Berhad is now they have two choices. Either they want to reduce the number of shareholders to 50, or they can proceed with 57 shareholders. But it is advisable for them to change the status of the company from private company to a public company, so that they can continue doing their business without any problem. In conclusion, Tuba Energy Sdn Berhad cannot have 57 shareholders as it is a private company, but they can do that if they change their status to a public company. I think that's all for me. Thank you.
Hi, my name is Anis and I will proceed with the second question, where we need to justify whether either Mr. Razi or Company X should be responsible for the secret profit made from Kelim Berhad. For your information, Mr. Razi is a director at Kelim Berhad and at the same time the sole shareholder and director of the Company X. For this, we need to look at Company X 2016 under liability, where it is clearly stated that when there arises conflict of interest between the director and the shareholder of the company, any director that violates its fiduciary obligation for his own interest must be personally responsible and not the company. Here are some of the duties stated under this law. Under Section 175, in order to prevent conflict of interest, a director must avoid a situation in which he has or may have a direct or indirect interest that in conflict or may conflict with the company's interest. We may relate this question to the case of Fairview School Berhad vs India Rani Anak Perempuan Rajaratnam, as the promoter must not benefit from the firm profit without the company's permission. They must also disclose any possible conflict of interest in every transaction in the firm that may be involved. Another similar case is Per Festival vs Rick, about the director's duties toward the shareholders. A company's director are not trustee for the individual shareholder, and they must acquire their share without revealing existing negotiation for the sale of the company's undertaking. Applying the law to the present situation, Mr. Razi is the one that should be responsible because he is the offender. Toward Kelim Berhad, he had incurred secret profit from Kelim Berhad by taking advantage of his position as a director without Kelim Berhad acknowledgement and transferring it to Company X for his own interest. Kelim Berhad can get back the secret profit from Company X and also compensation from the Mr. Razi. In conclusion, Mr. Razi acts as the directors and also as shareholders must be responsibility for his fiduciary relationship. That's all from me. Thank you.
Hi, my name is Pisa Anak Laki Adam, and today I'm going to explain the third issue, that is it acceptable for a fully established organization to be bound by a pre-incorporation contract? First of all, what is a pre-incorporation contract? A pre-incorporation contract is based on Company Act 2016 under Section 65 subsection 1, any contract made at the time when the company has not been formed has effects as a contract or transaction made with the person purporting to act for the company or as agent for it, and he is personally liable on the contracts or transaction accordingly. While under Section 65 subsection 2 stated that company shall be bound by the contract, as if the company has been existent at the date of the contract or transaction and had been a party to the contract. Alright, so the case that we are going to refer is Ahmad bin Saleh and Waris versus Rawang Hill Resort Sdn Bhd 1995 3LLJ 211. So this case is about a plaintiff who entered into a pre-incorporation contract to sell a piece of land to the defendants. So the agreement mentioned all these points are: the issue arises when the defendant violates the agreement. So the court has dismissed the plaintiff to claim and allowing the defendant to counter any litigations during the agreement, even when he is absent. This is because the agreement made were approved under Section 35 Company Act 1965. So the plaintiff will bear from raising any issues they had before the trial, accepting the defendants as the legal entity in the original sales and purchase agreement. As a conclusion, a pre-incorporation contract is not binding on the organizations, as the person acting on behalf of a company is responsible for such contract or transaction unenforceable. That's all from me, thank you.
The last part in this video is conclusion. Based on the three situations, we conclude that maximum number of shareholders for a private company is 50 shareholders as required by SSM. Next, any secret profit made by someone that violated his fiduciary obligation towards the company for his own interest must be personally responsible. And last, pre-incorporation contract shall not be treated like a normal contract since it happened before the company was established. That's all from our group for part 1. Thank you.